Hello, welcome to today's webinar, Hot Topics in the Law. My name is Sarah Tirani, and I'm the Program Coordinator for Triage Cancer. I'll be moderating today's webinar. And before we dive into today's topic, I just need to go over some housekeeping. All callers will be muted for the duration of the webinar. If you have any questions or technical problems, please type them in the chat box to the side of your screen. This webinar is being recorded and will be available soon on our website for viewing, okay? And that's at triagecancer.org. At the end of the webinar, you will be redirected to a survey. Please take a few moments to fill it out and let us know what you thought of today's webinar. Hold on here while I advance my screen. Okay, we are grateful for the support of Novartis Pharmaceuticals and the Alliance for Fertility Preservation for sponsoring the 2018 Triage Cancer webinar series. As part of the accreditation process for today's webinars, I need to read this disclaimer and disclosure. So the disclaimer, this presentation is intended to provide general information on the topics presented. It is provided with the understanding that the author is not engaged in rendering any legal, medical, or professional services. Although this content was reviewed by professionals, it should not be used as a substitute for professional services. The disclosure. The planners and presenters of this program have not disclosed any pertinent financial relationships or conflicts of interest. Now, while this educational program has received commercial support from the previously listed sponsors, the content of the program has no relation to the commercial interests and organizations of products and services. And I'm pleased to let you know that we are offering contact hours for today's webinar. Triage Cancer is now an accredited provider of continuing nurses education for the American Nurses Credentialing Centers Commission on Accreditation. Therefore, nurses participating in the live webinar today may be eligible for one contact hour. In order to receive the contact hours, you must have registered for today's webinar. People who are listening in on someone else's computer are not eligible for credit. You must also attend the entire webinar. No partial credit will be awarded. And anyone watching a recording of this webinar is also not eligible for credit. It's only for people who attend live. Within 1 week of this webinar, complete the evaluation and post-test. You must receive a passing grade on the post-test to be eligible for contact hour. You will receive an email following this webinar, which will contain a link to the evaluation and post-test. Please note that on the evaluation, it asks for your name and email address. You must include these so that we can certify that you completed the evaluation. This email is the address we will mail the certificates, and we'll be sending those out within 4 to 6 weeks. Again, we are only offering contact hours to nurses at this point. Our application to become a social work CEU provider is still pending. If you have any questions or experience any problems, please email us at info@triagecancer.org. For those of you who aren't already aware, Triage Cancer is a national nonprofit organization that provides cancer survivorship education on topics that arise from the point of diagnosis throughout life. And we provide this education in a few different ways. First, we host a speakers bureau of experts on all types of cancer survivorship issues. These speakers are available to organizations putting on an educational event. You can read our speaker bios and request a speaker on our website. We not only participate in events all over the country, but we also host our own educational events for patients, survivors, caregivers, advocates, and healthcare professionals. We host a series of Triage Cancer conferences on a variety of cancer survivorship topics. This year's events will be held, the next events will be held in Reno, Nevada and Lewiston, Maine. We already finished our Ypsilanti, Michigan conference. Travel assistance is available for patients and survivors to attend the Reno event and the Lewiston, Maine event. So you can apply for that on our website as well. And as you know, we host a monthly webinar series. The next one will be on July 25th, and you can register for those on our website. In partnership with Cancer and Careers, we offer a free one-day training for healthcare professionals called Navigating Cancer, Work, and Finance. work in insurance. For more information, you can visit our website. And we also offer our own insurance and finance intensive. This is a comprehensive certificate program for oncology healthcare professionals and advocates on health and disability insurances and finances. We're hosting the next intensive in New Orleans on August 23rd. Registration is open on our website. In addition to our events, we offer a number of online educational materials and resources. Our quick guides are designed to be a snapshot of a particular topic. They cover areas such as health insurance, employment, clinical trials, financial topics, estate planning, and legal assistance. You may order hard copies of the materials on our website. We also provide educational animated videos on cancer survivorship topics. We have this one on health insurance basics with key information that you'll need to know about your health insurance plan, especially to minimize your out-of-pocket costs. These videos are available in English with Spanish subtitles. We also have state-specific resources on our site, including topics you will hear about today. And because where you live can impact what protections you have access to, we have charts of state laws on employment, disability, and health insurance related issues. And we also have cancerfinances.org, which is a site that we host in partnership with the SAM Fund that provides practical information on topics that can impact your finances. We also provide contact information for financial assistance resources. We just released a new module on education, which covers education rights in school, accessing accommodations, and dealing with student loans. Our educational blog not only provides great information about cancer survivorship topics, but because things are constantly changing in the cancer community, this is where we share any late breaking news. And we also have a monthly newsletter, which is where we announce all of our upcoming events. Now, with no further ado, I'm delighted to introduce you to today's speaker, Joanna Morales. Joanna is a cancer rights attorney and CEO of Triage Cancer. She has spent 24 years working in the cancer community, including as an adjunct professor of law at Loyola Law School, teaching cancer rights law, and for the John Wayne Cancer Institute's psychosocial care program. Joanna has presented hundreds of seminars on employment, insurance, finance, and advocacy. She's co-authored a book on cancer rights law for the American Bar Association. She's been published in Psycho-Oncology, Coping with Cancer, Women, and other publications, including a book entitled Work and Cancer Survivors. In 2010, she was recognized by the Los Angeles Daily Journal as one of the top 20 attorneys in California under the age of 40. Joanna, welcome.
Thank you, Sarah. Good afternoon, everybody. Today, we are going to cover some hot topics in the law. And there are a lot of existing laws that certainly have an effect on people in the cancer community. But what is interesting about the law is that it is constantly changing. So most of my law books from law school are actually out of date and really should be thrown away because the law is constantly being changed, not only by federal and state legislatures, but also by the Supreme Court and the other court systems around the country. But there are a few areas of law that are currently hot topics for the cancer community. And what we'd like to focus on today is medical marijuana, paid family leave laws, and death with dignity laws. And I do want to say, starting out, that Sarah mentioned we have a chart of state laws, and all of the laws that we're going to talk about today are actually covered on those charts in addition to many others. Now, some of these areas of law are very sensitive topics, and some of them have become political, but today we're going to talk about what the laws actually are, which states have them and which don't, and where some of these topics are really unsettled law. So it causes some practical challenges for patients trying to navigate these issues. And then at the end of the webinar, I'll talk about ways that you can engage in advocacy around these topics if they are of interest to you. So starting with medical marijuana, this is actually a very hot topic in the law and in the cancer community, and I would say generally speaking across the country, because as more patients report ways in which marijuana has improved their side effects, and some patients believe that their use of cannabis has even shrunk their tumors or cured their cancer, and as more states pass laws related to marijuana, more attention is constantly being brought to this issue. And unfortunately, more attention hasn't necessarily brought more clarity, as we'll discuss. So we'll start by going back in history a bit to talk about the transition of the legality of marijuana from legal to not legal, and then to sort of legal. So cannabis was actually prescribed as a legal medication from about 1850 to around 1937. And then in 1937, President Roosevelt signed the U.S. Marijuana Tax Act, which made prescriptions illegal of cannabis. And this was the ultimate political culmination of a discriminatory reaction to immigration, primarily from an influx of Mexican immigrants at the time who used marijuana. Interestingly, this law was the first time that the term marijuana was actually used in the law. And the argument was that if people actually understood that their cannabis was being taken away, that they wouldn't be able to pass this law. So they used the Spanish term for cannabis, which is marijuana. And then in 1969, in a Supreme Court case, the Supreme Court ruled that that particular law was unconstitutional on a technicality. So in immediate response, Congress actually repealed that law and passed a new law in 1970. And that law was called the Comprehensive Drug Abuse Prevention and Control Act of 1970. Within it was the Controlled Substances Act. And the Controlled Substances Act created a commission on marijuana and drug abuse. And interestingly, that commission actually encouraged that marijuana not be highly regulated and put on the schedule of controlled substances drugs. But ultimately, the US senators at the time disagreed with the commission's decision, and the senators actually listed marijuana as a Schedule I drug. Now, Schedule I substances are drugs or other substances that have a high potential for abuse, and that there is no currently accepted medical use and treatment in the US, and a lack of accepted safety for the use of the drug or other substance under medical supervision. So this is the highest regulation of a particular drug. So any Schedule I narcotics are illegal to possess, cultivate, distribute, or use. So no prescriptions are allowed to be written for Schedule I substances. So marijuana has been included in a class with drugs like heroin, LSD, and ecstasy. For perspective, Schedule II drugs include drugs like cocaine, oxycodone, morphine, and amphetamines, some of which can actually be prescribed by a healthcare professional. So putting marijuana on a Schedule I class really limited access to it. And ultimately, that's still federal law. So it is illegal to have, grow, distribute, or use marijuana, medical or otherwise, under federal law. So turning to state law, in 1996, California was the first state to actually allow medical marijuana. And it wasn't passed through legislation. It was actually enacted by voter proposition. So voters in California opted to have access to medical marijuana. And since then, 29 more states, DC, Puerto Rico, and Guam, have enacted medical marijuana programs. So 15 states now allow the use of CBD, which is a low THC, high cannabidiol, for medical reasons in limited situations or as legal defense. So CBD is actually an extract from marijuana, which is the non-psychoactive part of marijuana. So some of those states really provide very limited access to the type of marijuana that can sometimes be reported as being most useful to alleviate some of the side effects of cancer treatment. Now, the state laws are completely different. So there's differences in whether or not you have access to a patient registry or you get access to an ID card. Some states will actually allow dispensaries or retail sales, and some states won't. They just allow you to have access to it, but you can't actually go and buy it anywhere. Some actually specify specific medical conditions. So for example, in a state like Alabama, you can only get access to medical marijuana if you have epilepsy or a seizure disorder. So sometimes even someone who's diagnosed with cancer doesn't have access to the protections that are available in those states. Some laws will allow patients from other states to actually be able to use the medical marijuana that they have. But what's interesting about that is you can't take marijuana over state lines because that's illegal under federal law. Some states actually allow for minor use, some states don't. Some states allow it to just be a legal defense. So if you are arrested with medical marijuana, it's a legal defense to that charge. It doesn't actually allow you to have it. And some states have other types of conditions on the laws that are available. So for example, in some states, they legalize medical marijuana, but you can't smoke it. Now, some states have actually gone one step further than medical marijuana and have actually legalized the recreational use of marijuana. So the first state to do that was Colorado. And that's kind of an interesting thing, because to have laws that directly contradict federal law means that people could be doing something legal under state law, but still be prosecuted for violating federal law. And that creates a great deal of confusion under the law. Now, Colorado's law actually also wasn't through legislation. It was approved through a voter proposition in November of 2012. And retail dispensaries for medical marijuana in Colorado didn't actually open until 2014. But since then, a number of other states have actually passed legalization laws, and those include California, Alaska, DC, Maine, Massachusetts, Nevada, Oregon, Washington, and Vermont. And there are a number of other states that are considering it, and probably the closest to actually approving it would probably be New York. So this is what it looks like visually across the state or across the country. So the states in dark green have full legalization laws. The states in Kelly green have medical marijuana laws. The states in lighter green just have access to CBD. And then the states in gray have no marijuana access laws. So we're really only talking about a very small number of states and territories in the US that don't have some legislation related to marijuana. Now, late breaking news. As I mentioned, the law is constantly changing. So just on June 26th, Oklahoma voters actually approved a proposition to legalize medical marijuana. And this proposition, the way that it was written, expedited access. So that access was supposed to start July 26th, the program implementation. But the governor of Oklahoma, Mary Fallin, actually called a special session of the legislature because she was concerned over how loosely worded the proposition was, and they needed some better regulation, or she felt that they needed some better regulation. So just yesterday, she signed a bill implementing some strict rules around this voter proposition, which included things like smokable forms of marijuana actually won't be available at dispensaries. And it also requires that there's a pharmacist at all dispensaries in Oklahoma. So we'll be keeping an eye on how this law actually gets implemented as we move forward. Now, even though states have made efforts to legalize marijuana for medical or recreational use, it is still illegal under federal law. Now, the Drug Enforcement Agency, or the DEA, has continued to enforce the Controlled Substances Act and conduct raids on dispensaries, file asset forfeitures against any landlords who rented space to marijuana stores, and they even did things like confiscating doctors' licenses if they continued to prescribe marijuana. So under these types of actions, states really weren't very happy about this, and they tried to fight this through the courts, which ultimately led to the 2005 Supreme Court case, Gonzalez versus Raich, where the court held that the federal government actually has the right to regulate and criminalize cannabis at the state level under the Commerce Clause, even under medical purposes. So it basically confirmed that states don't have the power to pass medical marijuana laws that supersede the federal government's right to regulate. So under federal law, it's still illegal to have and to use medical marijuana. And then in 2009, the tide began to change a little bit. And the Attorney General released a report that said, it's not a priority to use federal resources to prosecute patients with serious illness or their caregivers who are complying with state laws on medical marijuana. So they really didn't think it was worth the time to be prosecuting individuals who are trying to get access to medical marijuana legally in their state. And then in 2013, the Department of Justice announced an update to marijuana enforcement policy. And this update is referred to as the Cole Memo because there was an Assistant Attorney General named Cole. And so it acknowledged that marijuana still remains illegal under the Controlled Substances Act, but it urged federal prosecutors to continue to enforce the CSA, but with 8 priorities in mind. And those priorities were limited to preventing distribution to minors, preventing revenue from being directed to illegal activities, to ensure that people weren't driving drugged, and to ensure that marijuana doesn't cross state into states where it is illegal, preventing marijuana activity from being used as a cover for other illegal drug activity, and stopping marijuana from being grown on public land. So this really prioritized for federal prosecutors where it would be worth their time to make sure that the law is followed versus going after individuals who are using medical marijuana to try to alleviate some of their health symptoms. So after the Cole Memo, the federal government really relied on state and local authorities to address any marijuana activity at the state level, keeping in mind those 8 areas of protections. And so the Department of Justice actually informed governors of states that have legalization laws that they're not going to challenge those legalization laws. Then in 2014, Congress actually slipped quietly into a budget bill the requirement that it is illegal to use federal resources to impede state medical marijuana laws unless someone is guilty of other types of laws. So Congress really said, we don't want to be spending our federal resources on going after individuals who are trying to alleviate their symptoms by using medical marijuana in states where it's legal. More recently, in January of 2018, Attorney General Jeff Sessions issued a new memo that actually rescinded the Cole Memo and allows federal prosecutors to decide how to enforce federal marijuana laws. And so it directs U.S. attorneys to think about the priorities set by the Attorney General and to weigh considerations when they go after individuals who are using medical marijuana that is legal under state law. So there was a lot of conversation around this when it happened in January. And in March of 2018, also somewhat quietly, Congress passed another budget bill and extended their previous rule against using federal resources. So as you can see, there's been a lot of back and forth over the years around medical marijuana and the legalization of marijuana as it relates to the law. And it's pretty confusing and it's pretty contradictory. So it causes some practical problems and ultimately at the end of the day, some uncertainty about how someone is actually protected under the law if they decide to use medical marijuana. Now, the other challenge with accessing medical marijuana is that there's a significant amount of gaps in the research. So in 1999, the Institute of Medicine, or IOM, released a report on marijuana and medicine and looked at the science at the time. And they acknowledged the potential benefits of marijuana use to alleviate some of the side effects of cancer treatment, but they also expressed a significant amount of concern at the lack of research and the possible negative effects of usage. So they didn't recommend smoking marijuana because they thought that smoking could potentially be harmful. But they looked at the alternatives approved by the FDA at the time. There were two synthetic options called Marinol and Sesamet, which actually had been approved by the FDA. And so that report included a statement that there needed to be additional research. And so one of the things that they said was that scientific data indicate the potential therapeutic value of cannabinoid drugs, particularly THC, for pain relief, control of nausea and vomiting, appetite stimulation. Smoking marijuana, however, is a crude THC delivery system that also delivers harmful substances. The psychological effects of cannabinoids, such as anxiety reduction, sedation, and euphoria, can influence their potential therapeutic value. So they were saying that there are also psychological effects that come with accessing medical marijuana that could potentially be beneficial to patients, but then they also said that those effects are potentially undesirable for certain patients and situations, while they could be beneficial for others. In addition, psychological effects can also complicate the interpretation of other aspects of the drug's effects. So it left open the door for more research while expressing potential benefits and concerns of accessing medical marijuana. But 18 years later, not much has changed. So because of federal law and its illegality, it's difficult to research marijuana. So there's still limited information that we would prefer to be able to rely on when knowing the benefits and potential harms of using medical marijuana. So in a 2017 review of the health effects of cannabis, researchers concluded that scientific data indicate that there is potential therapeutic value. But despite increased cannabis use and a changing state-level policy landscape, conclusive evidence regarding the short and long-term health effects, both harms and benefits of cannabis use remains elusive. So it just again highlighted the significant need for research. Now, what's interesting about that is that significant need for research hasn't necessarily limited oncologists' suggestion of the use of medical marijuana. So just a few months ago, a study in the Journal of Clinical Oncology surveyed oncologists and found that 80% of oncologists were discussing medical marijuana with their patients. But a full 30% didn't feel informed enough to make recommendations to patients. And 46% have actually recommended it. 67% view it as a helpful pain management aid, and 65% view it as helpful for unintended weight loss. But ultimately, that study also called for additional research, clinical trials, and education of the healthcare team around the use of medical marijuana. Now, while there is much more attention being devoted on how to research medical marijuana, we still don't have a lot of data. We also don't have a lot of regulation. So quality control is a serious issue. And some analysis of available medical marijuana has found contamination by things like fungi and bacteria. Sometimes heavy metals or pesticides were found in the medical marijuana, or chemicals related to growth enhancers to grow the marijuana, and then even some substances like glass beads that are intended to increase its weight or give the appearance of a higher potency. So those are all serious concerns for someone who's trying to access medical marijuana and potentially has a compromised immune system at the same time. So we could actually be causing more challenges than we're solving. Dosage is also a serious question. So there's little regulation around the potency, quality, labeling, the types of strains, around edibles. Do you know how much you're actually getting in a brownie? And then the potential for overconsumption. So how do patients actually make decisions on how much is actually going to help them? And so are they overconsuming? And then there's also relatively little known about the long-term impact of medical marijuana use. So UC San Diego, about 2 years ago now, has shared some research on the impact of marijuana on different age groups. And their research has continued. But one of the things that they found is that it does affect brain development before birth and can cause lasting effects into adulthood. Access is also a practical problem for patients. So I mentioned that state laws may actually allow for the license to get access to medical marijuana, but they don't allow you actually to grow your own or buy it at a dispensary. So how are you actually going to get access to it? It's also a concern about finding a reputable and safe place to buy, depending on which state that you live in. That could be very, very different. Cost is also a major access factor because medical marijuana is not covered by insurance. So you're paying out of pocket. And then for patients who are traveling to treatment or just traveling at all, if you are flying, you cannot fly with marijuana because it's illegal under federal law, and you can't take it across state lines. So if you are traveling, you have to think about that piece as well. And then it can also actually impact access to care. So sometimes positive illegal drug tests can impact certain treatment decisions and could potentially impact your ability to access a clinical trial. So for example, in the context of the opioid crisis, CDC guidance has come out that asks doctors to not discount patients who test positive for illegal drugs when deciding whether or not to give them treatment for opioid use. So because it is still an illegal drug that shows up on a drug test, there are some assumptions made about that that could potentially impact access to care. Now, another area of practical concern for patients who are using medical marijuana is how it might affect their job. And I feel like this is one of the more under-discussed areas when it comes to talking about medical marijuana. So even if medical marijuana is legal in a state, employers are still allowed to have a drug-free workplace, with some exceptions. So the legal landscape on this topic has shifted considerably over the last year even. And ultimately, employers are not required to permit the use, possession, or impairment of employees during work hours. But in 2016, in Garcia versus Tractor Supply Company, the US District Court in New Mexico actually dismissed a lawsuit from a newly hired employee who was fired for failing a drug test for taking medical marijuana, even though it's legal under New Mexico law. Now, this court case just followed a number of similar court cases in a number of states and ultimately found that employees could still be fired if they test positive on a drug test, even if they have a doctor's recommendation and even if it's legal under state law. So they said that the reasonable accommodation of an employee to use medical marijuana is actually not required under the law. So what are reasonable accommodations? Under the Americans with Disabilities Act, the ADA, and most state fair employment laws, reasonable accommodations are any change in the work environment or in the way that things are customarily done that enable an individual with a disability to enjoy equal employment opportunities. Now, if you're not familiar with accommodations or would like more information on how they can help individuals at work, we have a number of resources on this topic on the employment page of our website. Accommodations can be things like changes in schedule, in workspace, or utilizing technology, but they could also involve a change in a workplace policy, something like a zero tolerance policy for someone who uses medical marijuana. So there's been an argument made that an employer may have to accommodate an employee's off-site, off-duty, off-work hour use of medical marijuana if they're eligible for protection under the ADA. But the problem is that it's still illegal under federal law. So generally speaking, employers are required to accommodate an employee if they are eligible for protection under the ADA or state law, unless it poses an undue hardship on the employer or poses a direct threat either to the employee, him or herself, or to others. So for example, there are classes of employees who also have to meet other requirements. So like airline pilots still have to meet FAA regulations, and truck drivers still need to meet the Department of Transportation guidelines. So there are certain roles that people play where they could potentially pose a direct threat to people around them. So for example, we don't want our airline pilots taking oxycodone on the job. Now in Garcia, the court ruled that reasonable accommodations are not required for illegal drug use. And as I mentioned, and we'll say again, for emphasis, it is still illegal under federal law to use medical marijuana. So the ADA doesn't protect an employee or an applicant who is currently engaging in the illegal use of drugs when the employer acts on the basis of such use. So the word currently is actually kind of a challenge in this circumstance because the time frame in which marijuana can actually show up in a drug test could be very far out. So it could be even weeks sometime. So someone will, for example, have smoked marijuana a few weeks ago and then takes a drug test and they test positive. And that's very different than other types of medications like oxycodone, for example. Employers are also not required to accommodate recreational use of medical or marijuana. So for example, the Colorado statute actually specifically says that employers are not required to accommodate recreational use versus Washington, for example, who doesn't specifically address workplace accommodation. But generally speaking, at that point, employers are expected to comply with federal law. Now, some state medical marijuana laws actually provide some explicit protections for employees. And so you'll see on the slide a list of states that have some protections, but those protections are sort of all over the map. They vary widely from state to state. So for example, in Connecticut and Delaware, there are state laws around medical marijuana that actually mandate employers accommodate someone who uses medical marijuana, which is pretty interesting. But then in some states, medical marijuana users are just protected by state law against discrimination for their use of medical marijuana. So for example, in Arizona, an employer might start to treat an employee differently because they find out that that employee uses medical marijuana off duty. And that actually wouldn't be permitted under the state law. Now, there is a case, Nofsinger, that rules that state law protections are not preempted by the illegality of federal law. So that's kind of a mouthful, but effectively, it's significant because just because it's illegal under federal law to use medical marijuana doesn't mean that the state law protections aren't still valid. So employers do need to comply with the state law protections that are offered to people in their state. But then what happens when a state law is silent on accommodation? It doesn't actually have any language that says whether or not an employer has to accommodate an employee based on their medical marijuana use under the ADA. So prior to 2017, state courts followed federal ADA law and said that employers don't have to accommodate. But then, just last year, there was the Barbudo case. And in that case, the court held that employers must accommodate off-duty use of medical marijuana if using medical marijuana is legal under the state law. So that's pretty significant. And they found that to be the case because they focused on a line in the Massachusetts law that said any person meeting the requirements under this law shall not be penalized under Massachusetts law in any manner or denied any right or privilege for such actions. So basically, an employee can't be fired and ultimately be penalized for using medical marijuana by their employer. So this was a real shift in the way that courts were looking at this particular issue. And while this case was specifically in Massachusetts, it's significant because many state laws that are silent on accommodation actually have the same language in their laws. So we are likely to see that other states find this case persuasive, and it leaves a door open for protection from employers for the use of medical marijuana. But it's still an uncertain protection in most states. Now, the duty to accommodate medical marijuana use isn't unlimited. So someone still has to be eligible for protection under the ADA or state fair employment law. Also, your access and your right to reasonable accommodations is also not unlimited. So if an employer can provide an alternative accommodation, they're not required to accept the employee's preferred accommodation. So in this case, the use of medical marijuana. Also, employers can claim that it's an undue hardship. And this is most significant where you have employers that have to comply with other federal and state requirements. So for example, if an employer has a federal contract, those federal contracts require employers to have a zero tolerance policy. Or for example, Department of Transportation regulations, or maybe employees are required to have a federal government security clearance which doesn't allow the use of illegal drugs. So there are some other nuances related to specific employers who could then use that nuance to claim it's an undue hardship to accommodate an employee's use of medical marijuana. It could also be safety concerns, or there are certain classes of workers who are on call. So even when they're off duty, they're on call. So even if they're using medical marijuana off duty, if they are on call and get called in, you don't want them to potentially be impaired by their use of medical marijuana. So those were all practical problems for patients in deciding whether or not and how they would be using medical marijuana. But there are also some practical problems for healthcare professionals. Because ultimately, how do you adequately advise patients on what to do if you don't have enough information? And so that goes back to that survey of oncologists who felt like they didn't have enough information to be able to adequately advise patients on their use of medical marijuana. And there's also something interesting about potentially advising patients to do something illegal. So what types of ethical problems does that pose for healthcare professionals? And it's a well-established ethical principle to have a duty to warn patients in certain circumstances. And so does that duty to warn actually apply to this circumstance? So is there a duty to warn patients about access and quality issues of medical marijuana? Do we know enough about interaction with other treatments or other comorbidities and medications that someone might be taking for those comorbidities? Should healthcare professionals be warning patients about how this might affect their employment or their ability to drive or other areas of their law? It is a very open question, and there is a need for more information to be gathered and ultimately to be shared with patients and healthcare professionals. So turning now to paid family leave, I'm going to share some information about current laws and pending legislative efforts to help people access time off from work, mostly as a caregiver for family members. And in the mind of some, paid family leave should focus just on new parents, what we think of maybe as maternity or paternity leave. But in the cancer community, we understand the importance of having access to a broader scope of family and medical leave. So we do have a number of resources on our employment and disability pages of our website around family and medical leave and other employment resources that are available. But I did want to just start by saying there are options available when taking time off work, and they fall into two categories. So there's individuals with disabilities who are taking time off for their own serious medical condition, have access to unpaid leave under the Family and Medical Leave Act, as well as some states which have FMLA type laws. And then there are some paid leave options, which mostly fall under the category of disability insurance. And there's different types. So you can have a private policy as an individual. You can have a private policy that you get through your employer. There's a handful of states that provide state disability insurance options. And then there's also the federal long-term disability programs, supplemental security income, and Social Security disability insurance. Now, for a caregiver who needs to take time off work to fulfill caregiving responsibilities, the FMLA can also be a useful tool. But the challenge is that while it provides up to 12 weeks per year of job protected leave, it's unpaid leave. So whether that's available under the federal FMLA or a state FMLA law, that still poses a problem. Now, there are some paid leave options in some states, and there are some other programs that might be available, but it depends greatly on the states that you are living in. And I want to spend some time talking about paid leave for caregivers. So why is this a topic that we care about? And ultimately, 100 million people, which is about 85% of workers, don't have any paid family leave through work. And 60% lack access to paid personal medical leave through their employer. So even the FMLA's unpaid leave is not even accessible to nearly 2/3 of employees because either they're ineligible for it or they can't afford to take 12 weeks of leave unpaid. What's also interesting is that while there is a focus on maternity or paternity leave, 75% of people who take FMLA leave don't use it for maternity or paternity leave, but are either caring for family members with a serious illness or for their own serious health issue. And this is significant because the majority of parents, adult children, and spouses who care for ill family members also have paying jobs. So they're contributing to the household income, and most of them work more than 30 hours a week plus their caregiving responsibilities. So there's a need for those individuals to have access not only to that unpaid leave job protection, but also to replace those lost wages. And so that's why paid leave is so important. So one option is state-sponsored paid leave. So there are now 5 states and the District of Columbia, that provide paid leave benefits for caregivers: California, New Jersey, New York, Rhode Island, Washington, and DC, as outlined by this table. And each jurisdiction has different requirements, including the definition of which family members caregivers can care for and be eligible for those benefits. Some states allow employees to take time off work by using their own sick leave to care for a family member. And then every state law is a little bit different. So the amount of wages a state paid leave replaces actually depends on that state law. So in some states, it's only 50% of your wages, and in other states, it can be up to 90%. Now, some of these laws were only recently passed, so you'll see Washington and Washington, D.C.'s laws actually haven't gone into effect yet, so they only recently passed and they're ramping up to provide access to this benefit. So paid family leave advocates across the country are currently working on passing legislation at the federal, state, and local levels. And some paid leave laws are focusing only on leave for the birth or adoption of a child, while others include caregiver leave for a family member with a serious medical condition. So this is what it looks like most recently. but cities are even getting into the mix. So for example, in San Francisco, the County Board of Supervisors unanimously approved full pay for up to 6 weeks of family leave for birth or adoption of a child. Now, unfortunately, that doesn't apply to caregiver leave, but cities are starting to fill in where states and the federal government have sort of failed to provide these protections. Now, turning to paid leave legislation at the federal level, there is currently a bill in Congress called the Family and Medical Insurance Leave Act, or the Family Act, that allows employees to earn up to 2/3 of their wages for 12 weeks a year. So it's basically providing a paid leave counterpart to the unpaid FMLA. So this particular law is currently being discussed. Just this week, the Senate Committee on Finance Subcommittee on Social Security, Pensions, and Family Policy held a hearing about the Family Act. So this is a very timely legislative issue. So if you're interested in this issue, I would take a look at the website for the National Partnership for Women and Families, who takes a lead on this particular issue. But there's an alternative proposal that's been floating around that was proposed by Senator Mark Rubio from Florida. And this proposal is to allow people to borrow from their Social Security retirement funds. And it only focuses on caring for new children. So it doesn't have that caregiver option, or to allow people to take time off for their own serious health issue. So it's limited in that regard. And there's some concern that's been expressed around depleting the Social Security Trust Fund if we allow people to borrow from it. Now, turning to state legislation, there are many efforts to pass state paid leave legislation, which you can actually track at paidleave.us. And in 2018, 30 different states actually considered legislation to create new or expand existing state paid leave protections. So 30 states is a significant portion of the US, but of those proposals to date, only Massachusetts was signed into law by the governor just recently on June 28th. And these paid benefits are for employees who need to take time off either for a serious health issue or to care for a new child or sick family member. So it provides those protections and will go into effect in the future. So turning to laws and legislation around end-of-life choices, Triage Cancer has a number of useful resources related to estate planning on our website. And talking about estate planning and end-of-life care is a very sensitive subject, and everyone has their personal feelings around this topic. And so maybe somewhat surprisingly, 7 in 10 Americans actually support death with dignity laws. And these laws are also known as physician-assisted dying or aid in dying laws. And they allow individuals who are terminally ill to make end-of-life decisions and determine how much pain and suffering they actually want to endure. And so these death with dignity statutes allow an individual who's mentally competent and an adult with a terminal illness to voluntarily request and receive a prescription medication from their physician to hasten their imminent death. And so it actually gives some patients some dignity and control and peace of mind around their final days. Now, doctors are not required to prescribe these life-ending medications. They can actually decline. So if your doctor declines, you can certainly find a new physician who is supportive of your choice. And one of the most important arguments made by advocates for death with dignity laws is that those who assist individuals in these circumstances and those who choose to take these drugs are not engaging in suicide or homicide or even assisted suicide. And this distinction is important to ensure that individuals don't face criminal charges and that individuals who choose this option will still be eligible for insurance benefits like life insurance. So there are currently 6 states and Washington, D.C. that have death with dignity statutes. Oregon really paved the road with their Death with Dignity Act. And Hawaii actually just passed their law a few months ago. Each state's law is slightly different, so it's important to learn about what options are available to you based on where you live. In addition, Montana actually doesn't currently have a statute allowing physician-assisted death, but in 2009, Montana's Supreme Court ruled that there was nothing in the state law that prohibited a physician from honoring a terminally ill patient's decision around their death. And so since then, several bills have been introduced to codify that Supreme Court decision, but nothing has actually passed yet. And some late-breaking news. Some of you may have heard that California's End of Life Option Act was recently struck down. And this is actually the latest situation. So ultimately, there's been court proceedings around the Superior Court judge's decision to suspend this law. And while it is going through that legal appeals process, the law is currently in effect. So as of June 15th of this year, it is still in effect, pending some future rulings that come out of the appeal related to this case. So this is where death with dignity laws currently stand across the country. The dark green states have a statute. The light green state is Montana. The light orange states are considering laws this year, and the dark orange states are not. So 23 different states introduced bills in this legislative session, and some introduced statutes for the very first time this year, like Ohio. Some of these proposals are actually inactive. They've been stuck in committees at the state legislature, but some of them are still active. So for example, Ohio's Aid in Dying Act is still being considered by the legislature. There's also some voter proposition efforts happening right now. So there's advocacy groups in Maine who are trying to get a proposal on the 2019 ballot. So if you are interested in any of these laws or in the many other areas of legislative and legal issues that can impact the cancer community, we strongly encourage all of you to engage in advocacy efforts. And so this is a definition of advocacy that I feel strongly about. It's the application of pressure and influence on the people or institutions that have the power to give you what you want. So there's lots of different types of advocacy, but you can engage in advocacy on your own. You can join an existing organization's advocacy efforts. There are many organizations in the cancer community that engage in advocacy, and you can certainly vote. So if you are a first-time voter, we actually just put out a blog over the last 2 weeks on things that you should know before you vote. But we also have a number of resources on the advocacy page of our website about how to get more involved. And as a reminder, on July 25th, we have a new webinar that we are offering on making your voice heard related to legislative advocacy. So I recommend that you participate in the webinar if you want some more details. So with that, I'm going to turn it back over to Sarah.
Sorry about that. I muted myself and I didn't figure out how to unmute myself. So here we go. Oh, we mentioned before that Joanna co-authored a book with actually her sister, Monica Bryant, and that's called Cancer Rights Laws. And you can buy that on our at the site listed there, www.ambar.org, Cancer Rights Law. And there is a 35% discount code that is available if you type in Triage Cancer. So thank you, everyone. That is all the time we have today. It's already 2:01. If you would like more information on any of the topics discussed or would like to stay in touch with Triage Cancer, you can email us at info@triagecancer.org. And like I said before, sign up for our newsletter on our homepage at triagecancer.org. And please connect with us on social media, including Facebook, Twitter, Instagram, and take a look at our blog at triagecancer.org/blog. And again, I just want to go over the rules for the contact hours. So for nurses, in order to receive contact hours, you must have registered online for today's session. People who are listening in on someone else's computer are not eligible. And remember, you need to attend the entire webinar, so hopefully you're listening right now. No partial credit will be awarded. Within 1 week of this webinar, you have to complete the evaluation. That link will be sent to you right after this ends. And please remember that that evaluation asks for your name and email address, and you must include those so that we can certify that you actually attended. We are, again, only offering these contact hours to nurses at this point. If you have any questions or problems, please email us at info@triagecancer.org. And with that, this concludes today's webinar. Thank you.